Hi, my name is Nicole Hemrick, and I'm the managing attorney at Hemrick O'Malley PLLC, which is located in New York City. Today, I'd like to talk about a new rule that USCIS proposed to modernize the H1B specialty occupation program. This was announced on October 20th, 2023, and there is now a 60-day comment period before USCIS implements these changes. What are these changes? Number one, many of us know that in past years, specifically this year, there has been a problem with multiple entries for the same beneficiary during the H-1B visa lottery. So, in order to counteract the inflation of chances for some applicants, employers can no longer file multiple entries for the same employee. Each employee can only be registered once, and the employer must submit passport information for the employee to ensure a fair selection process. Any attempts to bypass this rule will lead to revocations or denials. Also, now this is a positive change too. In the past, entrepreneurs could not self-petition for H-1Bs. Now, the rule is going to change so that for anybody who is a 50% owner or less, you can self-petition for an H-1B. Additionally, and this is one of the pluses that came with COVID, we all learned that we can work remotely, as my team often does. So now DHS permits remote work to get in line with the reality of working circumstances these days. Frankly speaking, we have been doing this for many of our H-1B workers anyway. And in these cases, we've been posting LCA notifications both at the potential employee's home and at the office. But this, I guess, envisions a situation where it's only a remote job. Another practical change: in the past, as you know, students would get cap gap protection between the end of their OPT status until the H-1B started. Now what's going to happen is that international students are going to be able to extend their F1 OPT until April 1st of the following year, or until they receive their H-1B visa, whichever is sooner. Another change, also positive because it's to reduce fraud, just something for employers to be on the lookout for, is that there's going to be greater oversight. There has always been a program for site visits to employers, but now USCIS is going to ramp that up in order to ensure compliance with H-1B regulations. Additionally, there's going to be greater scrutiny as to what specialty occupation means. USCIS is going to require a greater connection between the potential beneficiary's degree and the proposed job duties. Furthermore, in terms of CAP-exempt organizations, USCIS intends to add certain research organizations as being CAP-exempt. So that is going to open up the opportunity for additional possible employees to not have to go through the CAP in order to get an H-1B visa. Unfortunately, the total number of visas available for CAP subject H-1Bs is still only going to be 85,000. Again, 20,000 reserved for people with U.S. masters from public universities in the U.S. And the rest, again, second bite at the apple for people with U.S. masters plus people with bachelor's degrees or the equivalent. Finally, let's just remember the H-1B cap typically runs in March. At Hemrick O'Malley PLLC, we're usually lining up, starting to collect information about potential H-1B registrations in January and February prior to the March cap season. So if you are interested in potentially sponsoring an employee for this sort of visa, or if you are an employee and you believe that your employer might be willing to sponsor you, feel free to reach out to us to discuss this or any other matter. Our number is 833-848-7838. Thank you very much.